Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 500 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Class X felonies lawyer in Illinois. Class X felonies are among the most serious charges people can face in Illinois, with conviction often carrying mandatory imprisonment. The Illinois criminal defense attorneys at Combs Waterkotte have over 60 years of combined experience fighting for the rights of people just like you who have been accused of such offenses throughout the state. If you've been charged with a Class X felony, hiring our team is critical for protecting your future. States have considerable discretion in defining the sentences for criminal offenses. However, the Constitution's prohibition of cruel and unusual punishment requires some level of proportionality. In other words, the penalty should, objectively speaking, fit the crime. Illinois accomplishes this goal by classifying felonies into these levels: Class 4 felonies, Class 3 felonies, Class 2 felonies, Class 1 felonies, Class X felonies. Class 4 felonies are the least serious and carry the least severe penalties, while Class 10 felonies are reserved for severe offenses with the harshest penalties. Notably, first-degree murderers, second-degree murderers, and habitual criminals fall outside the felony classifications. Generally, only those convicted of first-degree murder or classified as habitual criminals face life imprisonment under Illinois law. Illinois statutes covering Class X felonies. The Illinois statutes include many offenses classified as Class X felonies. These crimes cover homicides, violent crimes, sex crimes, and some property crimes. Additionally, a few serious drug crimes also qualify as Class X felonies. The following criminal offenses fall into this classification: homicide. First- and second-degree murders fall outside the felony classifications, and manslaughter is usually treated as a lower-class felony. However, 3 offenses relating to homicide can be classified as Class X felonies. Drug-induced homicide occurs when someone causes a death by violating Illinois drug laws against delivering controlled substances. Solicitation of murder happens when someone commands or requests someone to murder someone else. It's important to note that solicitation is a crime even if the other person does not carry out the murder. Finally, attempted first-degree murder is a Class X felony. Attempt means that the accused had the intent to commit first-degree murder and took a step in furtherance of their plan. Violent crimes. Several violent crimes are classified as Class X felonies under Illinois law, including aggravated kidnapping of a child, aggravated kidnapping for ransom or with a dangerous weapon, human trafficking involving the involuntary sexual servitude of a minor, aggravated battery with a firearm. Many other violent crimes are classified as lower-class felonies. Thus, one option for defending against these charges is to seek a reduction in charges based on mitigating evidence. Property crimes. A few property crimes qualify for Class X felony punishment. These crimes usually involve valuable property, harm, or threats of harm, such as armed robbery using a dangerous weapon or firearm, aggravated vehicle hijacking committed against a disabled person, with a minor in the vehicle or while armed, home invasion while armed or that results in an intentional injury, aggravated arson when the accused knows or should know that people are present, theft of property worth over $100,000 from a school, church, or government, theft of property worth over $1 million. The thefts that qualify as Class X felonies can be accomplished by taking the property or deceiving the owner into giving it to the accused. This means these thefts do not require violence or threats. Sex crimes. Many sex crimes fall into the Class X category, including a repeat offense of criminal sexual assault, aggravated criminal sexual assault, predatory criminal sexual assault of a child, arranging for an adult over 17 to have sex with a child under 13, promoting child prostitution, producing or distributing child pornography consisting of a video or film. In addition to the risk of mandatory imprisonment, these offenses also require the accused to register as a sex offender after their release. Drug crimes. Drug crimes, particularly those on the supply side of drug transactions, can qualify as Class X felonies, including the following: manufacturing, delivering, or possessing drugs with the intent to distribute. Participating in a criminal drug conspiracy. Participating in a street gang drug conspiracy. Certain drug charges can also be elevated to Class X felonies based on the location. For example, manufacturing, delivering, or possessing with the intent to distribute small amounts of drugs is typically treated as a Class I felony. However, it can be elevated to a Class X felony when it occurs on school grounds, church property, or senior center property. Possible defenses against Southern Illinois, Class X felonies. The defenses we raise against Class X felonies depend on the nature of the offense. For example, we could assert a claim of right in a defense against theft. However, this defense does not work in homicide or sex crime cases. Thus, our attorneys tailor any criminal defense strategy to match your specific evidence and charges. Some defenses we may be able to leverage in your case involve lack of proof, consent, alibi, or lack of intent. Lack of proof. Class X felonies require prosecutors to have evidence beyond a reasonable doubt of every element of the offense, including any circumstances that elevate it to a Class X felony. Sometimes, this requirement can work in your favor. For example, we may be able to argue that the prosecution has no proof that you possessed a weapon to justify a Class X felony charge of armed robbery. You may still face robbery charges, but you could avoid the harsh penalties that come with Class X felonies. Consent. Consent is a defense to some sex crimes, such as criminal sexual assault. If applicable to your case, we can present evidence or witnesses to prove that the alleged victim consented to the sex act. Alibi. Our attorneys may also be able to present evidence that you did not commit the crime because you were elsewhere at the time. For example, you might have alibi evidence such as security video, proving that you were at the store when prosecutors allege you committed a home invasion. Lack of intent. Felony offenses usually require knowledge of the circumstances and intent to commit the prohibited act. Prosecutors must prove your intent beyond a reasonable doubt. Our team can defend you under this principle by poking holes in the prosecution's evidence or presenting an alternate explanation for what occurred. For example, perhaps you lacked the intent to distribute drugs if you possessed them for your personal use. Our Southern Illinois Class X felony attorneys have handled over 10,000 criminal cases, many of them involving allegations of serious offenses. We take pride in providing compassionate and aggressive defense, regardless of the charges our Southern Illinois clients face. Our firm strongly believes that everyone is entitled to a zealous defense of their legal rights. Our Southern Illinois criminal defense lawyers can thoroughly analyze the case against you and identify any weaknesses in the prosecution's case. If necessary, we can hire experts to retest and re-examine the evidence against you. Additionally, our Class X felony defense lawyers can interview witnesses and craft a tailored defense to meet your goals. With over 400 five-star reviews as testament to our commitment to providing exceptional representation to every client, you can rest assured that we know how to successfully advocate for your future. Class X felonies are often high-profile cases. We fight for a fair process despite the negative publicity you may face. Our Class X felony lawyers learn your side of the story and work diligently to obtain a positive outcome. We also preview your defenses and arguments for the prosecution to argue for a dismissal or reduction in your charges. Class X felony cases often carry harsh penalties, and pleading the case down to a lower class felony or misdemeanor might prevent you from facing years or even decades in prison. If the prosecution does not offer a fair plea deal, we can take your case to trial. We can then present your evidence and argue aggressively for an acquittal from the jury.